like most people, you have an IRA and have been contributing yearly in the hopes that you'll have a nest egg when you retire. But recently, new legislation that was signed will impact your IRA. This new legislation is called the Secure Act, which stands for Setting Every Community Up for Retirement Enhancement. On this special episode of Hilary Topper on Air, Vincent Russo of the Russo Law Group on Long Island will explain to us what this all means and how it's going to impact our IRA, our estate planning, our wills, and more. And without further ado, I'd like to introduce you to Vincent Russo. And Vincent, welcome back to the show.
It's always great being a guest on your program, and I'm really excited to talk about the changes in the IRA rules, because what the public is hearing may be not the reality of the situation. So I think this is going to be a real eye-opener for everyone. I am going to, as you've requested, do this in roughly 25 minutes, even though it probably takes about an hour. So I'm going to move fairly quickly and give you the highlights of the Secure Act. And so this was part of a change in the law that came in at the end of the last year in December, where they had to basically deal with the federal budget. And in there, they tucked this section called the Setting Every Community Up for Retirement Enhancement. Wow, that sounds really good, but we're really going to drill down and understand what this means. And so there were a number of changes made in the IRA rules. And also it would include 401k plans, for example. So qualified benefit programs in general. What I'll say up front is certain parts of the IRA rules did not change and certain parts did change. And I'm going to try to highlight the important ones here. So we've all been told for many years that we've got to tuck money away into our IRAs so that we'll have enough money when we retire so we can have a quality of life in our retirement years. And the real challenge has been, where do we find the money to put into those IRAs? And we're all living longer, so it's harder to have enough money. But that's been the path. And pensions, for most people, there aren't even an option. So 401k plans became really important. So the government basically laid out a general rule that when you turn 70 and a half, that you would have to start taking out your retirement benefits on an annual basis. And there was a chart telling you how much you have to take out. And so if you turned 70 and a half, by April 1st of the following year, you had to take a payment for the year you turned 70 and a half, in effect. So they've changed that rule, and it sounds good because the new rule says that if you were under 70 and a half on January 1st of 2020, now you'll be able to wait until you're 72 before you have to take out your required minimum distribution. They're called RMDs. So that's good news that for us going forward, we've got an extra 2 years of time to put money away into our retirement accounts that hopefully helps us later on in our retirement years. The other change that was a good one is that once you pass 70 and a half, in the past, you could no longer make any traditional IRA contributions. And so the change here, another positive change, is that you now can put, if you're still working, you can still add to your IRA account, even though you've passed the age of 70 and a half. And you'll be able to do that until you retire. So, for example, if Jack is working and he's 75 years old, he can still contribute to his IRA. Now, understand that at 75, Jack's past 72, so he's going to have to start taking money out, but he'll also be able to put money in. So there'll be some benefit to that. Also, they gave a break for younger people under 59 and a half, where if you take IRA money out, it's subject to a 10% penalty and also subject to income tax. And they've added another exception to the rule, which would allow an individual to take up to $5,000 out to pay for related expenses due to a birth of a child or an adoption. And so parents together could take $10,000, $5,000 out of each of their IRA accounts and use that money to help with those expenses. Another positive change. Also, another positive change I want to highlight is that part-timers, people who are working less than 1,000 hours, could not participate in retirement plans offered by employees. The new rule has changed that says if they work in hours, so 1,000 hours, if you hit that benchmark as a part-timer, you're able to now participate in the plan. Or if you have 3 consecutive years of at least 500 hours. So part-timers who in the past could not qualify as a participant in a plan now may be able to with these changes, but there's no requirement for any matching funds by the employer. So it's a step in the right direction. The big change, though, and this is where the hammer comes down on all of us, has to do with what are called inherited IRAs. So when you have an IRA account, you're taking out your required minimum distributions, and then when you pass, whatever's left in that account passes on to the beneficiaries you've named, and that's what's now termed an inherited IRA. And in the past, you were able to take that IRA and stretch it out over the lifetime of the beneficiary. And so that was really good news, because the general rule is that when someone passes away, the remaining money must be paid out over 5 years. But the exception here was for individuals that if they were named as a beneficiary, we would look at their life expectancy. So if someone was in their 40s and had a 40-year life expectancy, then they could take it out in annual installments over the 40-year period based on the life expectancy chart. And that would be wonderful, because that IRA could grow tax deferred and not be subject to tax until it was taken out, and it would be stretched over that beneficiary's lifetime. That has changed dramatically. So now, under the new rule, beneficiaries are going to have to take those monies out over a much shorter period of time. And typically that means that they're going to be taxed at higher tax rates because they're still working as opposed to being retired. And the beneficiary will no longer get the benefit of additional growth earned during a longer period of deferral. So those good news things, those tweaks, 72, you still can throw money in, this comes back in a very large way. And this major change in the rules is really to collect more taxes quicker, to make up for the wonderful tax changes in the law 2 years ago, which helped the wealthy in large part. So what's the new rule? How quickly will I have to take it out? I'm going to have to take it out within 10 years. So one of the strategies that we've implemented as a planner here was the client who wanted to leave it to grandchildren and get a stretch for 60, 70, 80 years. Now it's going to be 10 years. So within that 10-year period, all of the money must be taken out. When that money comes out, it's going to be subject to income tax. And so that's going to help the government collect a whole lot more taxes. That's the bad news. Now, there is an underbelly here of some good news in that certain people can still get the stretch over their lifetime. And there are 4 categories of people: a surviving spouse, a beneficiary who is disabled or chronically ill, a beneficiary who's not more than 10 years younger than the original account owner. So if the person passed away who was the account owner at 75 and left it to a 70-year-old beneficiary, then they still could get the stretch over the lifetime of the 70-year-old. And beneficiaries who are minors, but only while they're a minor. So if you were 15 years old and living in New York and the legal age is 18, you'd get your 3 years plus an additional 10. So instead of the 10-year rule, you get 13 years. So like all law changes, there are a lot of complications, and they make it very technical. But so the general rule is, when you're thinking about your estate plan, understand it's going to basically have to be paid out to the beneficiaries. Parent leaves their IRA to 3 children. Those children, regardless of their age, as long as they're adults, are going to have to take it out within a 10-year period, subject to tax. Now, certain trusts can be used for a beneficiary. And so in the past, there were 2 types of trusts. One was called a conduit trust, and the other was called an accumulation trust. So instead of leaving the IRA to marry the child, one could leave it to a trust that was set up for Mary and still receive the stretch over a lifetime. That has changed dramatically. So now the general rule is going to be that it's a 10-year rule, that money's going to have to be paid out to the trust within 10 years unless you meet an exception to the rule. All right? Now, why would someone do a trust? Well, you might want to do a trust because the Mary, in my example, is a spendthrift. If she has access to the money, it'll all be gone very quickly, and it won't be used prudently. Or Mary has creditor problems, and the creditors can't wait to go after that account. And we learned from a case decision of the U.S. Supreme Court in 2014 that there is no creditor protection for inherited IRAs. Or Mary's in a bad marriage, and now the bad spouse would like to get their hands on that IRA account. Or Mary is disabled and wants to qualify for government benefits. So trusts were a very good vehicle for many, many of our families that we did planning for. And we not only were able to protect those assets using a trust, we were able to stretch it out over their beneficiary's lifetime if it was done properly. Now we're going to be subject to the 10-year rule, except we still can have a stretch for a disabled or chronically ill beneficiary. So if Jane, mom, leaves assets to Mary and Mary is disabled at the time she inherits the assets, they can go in a trust and be stretched over Mary's lifetime. So we've got a very narrow exception to the 10-year rule when it comes to trusts. Now, as mentioned earlier, there are 2 types of trusts, the conduit trust and the accumulation trust. A conduit trust is a trust where the IRA money would be paid out annually into the trust, and the trustee was required to give it to the beneficiary. So it would be, and that in the past would allow for the stretch over the beneficiary's lifetime. So let's say Jane had $100,000, left it in a conduit trust for Mary, and based on the tables, Mary has to take out the first year $5,000. So $5,000 would go from the conduit trust, from the IRA account to the conduit trust. Trustee would write out a check. We still would get the benefit of asset protection with a conduit trust. The child wouldn't have access to the $100,000, only the money coming out each year. Creditors couldn't attack the $100,000 because it was in a trust and not in Mary's name directly as a beneficiary. And if Mary was disabled, she could qualify for benefits, government benefits like Medicaid. Now the new rule says that trust still can work for certain people, but it's only going to be for 10 years. We're going to have to pay it out within that 10-year period to the trust. The trust can still hold the money and hold it in a protective way for the beneficiary, but the government's going to get its tax payment a lot sooner. because of that 10-year rule. So conduit trusts are going to now be forced into a 10-year rule, except for that disabled or chronically ill beneficiary. So what does all this mean for you? You have your IRA account. Everybody's in a different situation. You may have a relatively small amount. You may have hundreds of thousands. You may have over $1 million in 401k plans and IRAs. You may be still working, or you now may be retired. These new rules kick in immediately. So there's no grandfathering, basically, of these rules with regard to inherited IRAs. So I'm going to highlight a couple ideas and strategies for you to consider when you think about your IRAs. First of all, if you can stretch your IRA, there's a significant benefit, as I discussed earlier. It can grow tax deferred. It can be in a more protective way. So we still want to use the stretch IRA for any eligible designated beneficiaries. All right. So there were the 4 beneficiaries I mentioned, where we could have the spouse, the minor child, the disabled person, the person who's less than 10 years younger than the account owner. We still can use conduit trusts for those beneficiaries, but the money's going to get paid into the trust sooner. We're going to pay a tax. We can use what's called an accumulation trust for a disabled or chronically ill beneficiary. Now, how does that work? Well, that trust works in this way. The payments are paid out over the lifetime of the disabled beneficiary into the trust. The difference here now from a conduit trust is the trustee does not have to pay it out. The trustee can pay it out if they want, or they can pay it for the beneficiary, or they can accumulate it and keep it in the trust. So in my example, if Mary was disabled and on Medicaid, we don't want to pay it out into her name directly. That's okay in an accumulation trust. We could spend money for her and still keep our Medicaid. That's wonderful, and that can work. Or if we don't need to spend it, we'll hold it in a protective way so creditors can't get at it, bad marriage, spendthrift, and also the government benefit protection. So accumulation trusts are a huge planning opportunity for any family member who's thinking of leaving assets to a disabled or chronically ill beneficiary. But here again, I still think the accumulation trust works for all individuals that we want to leave assets to. Why would I want to leave $1 million IRA account directly to my son, Harry, and have it subjected to potential problems? And we all do this. We all name our children, grandchildren, family members as beneficiaries, and we leave it outright. We leave our IRA accounts outright. Now, we're not going to have the lifetime stretch. It'll be paid out over 10 years. But the question I'm asking is, why do it directly? Why not put it in an accumulation trust and protect it from all these bad things that can happen? My hope is it never happens to that beneficiary. But if it does, why not have that protection? So I think we all need to think about this. Now, this is a new law. There are no regulations. So there are a lot of technical provisions. So there is a lack of clarity as to how some of these rules are going to be implemented. And we're going to have to wait until there are regulations issued by the government that will explain in more detail the interpretation of this new law. So I'm going to recommend certain steps for you. Now, before I make that, so let me move into the recommendations because I have about another 5 minutes. Let's talk about a spouse, a surviving spouse. There are going to be several options for the surviving spouse. We still can have what's called a spousal rollover IRA. Now, what is that? That means that, let's say the husband, Harry, passes away. He can name Jane, his wife, the beneficiary, and she can roll it over into what's called a spousal rollover account. and she now is treated as the owner, and now the IRA rules would apply as to when she needs to pay it out, but it wouldn't be paid out based on her husband's age and his situation. So that's really the go-to approach in many plans. The other option is it can roll over into an inherited IRA, and then we could even have a conduit trust there to qualify, so that even though it's going to get paid out over 10 years, it stays in a protective way. So if I have a spouse that's elderly, or a spouse who I'm concerned about being taken advantage of, rather than do a rollover IRA, you could do an inherited IRA and then protect it using a conduit trust. So that's a good approach. A third approach is to roll it over and then convert the IRA to a Roth IRA. Now that gets a little more technical, so I just want to mention it right now. Or the spouse can say, if I don't need that money, I won't accept the IRA, and that's called a disclaimer. So depending on a person's situation in their retirement years, whether they need government benefits to pay for long-term care, or they're concerned about creditors, these are options that need to be considered. The key is that you're going to want to go to a professional who can really sit down with you in your particular situation and give you advice. Also, some of the planners, the financial planners out there, are saying maybe life insurance can help here. Maybe we take distributions out of an IRA, buy life insurance, and that life insurance replaces some of what's lost because we have to pay the tax sooner. It's another planning technique. And people who have taxable estates of over, if their estate is over approximately $6 million, they may want to use this strategy and then put that life insurance policy into what's called an irrevocable life insurance trust. More sophisticated planning that can potentially save income and estate taxes. Some of you are charitable minded, and so I just want to throw a quick shout out to help charities. During your lifetime, do you know that you could take your IRA money and pay it directly to a charity and avoid having to pay income tax? Well, that's a really good situation, because many of us make a donation. Let's say I want to give $1,000 away to a charity and help them out. I do it with after-tax dollars, so I have to earn like $1,300 or $1,400 to have the $1,000 to give it away. I could give that $1,000 away dollar for dollar directly from the IRA, or I could even give them the $1,400 and make them even happier. So there is a number of benefits by doing what's called a qualified charitable distribution, something to think about. Also, there's another provision in the IRA laws that allow you to name a charity in a charitable remainder trust. And what that means is you want to help your beneficiary, but after that beneficiary dies, you want to leave the remainder to the charity. You can do this and get the stretch IRA. So Jane could set up a charitable remainder trust. Mary can be the income beneficiary for life, and whatever's left at the end, it passes on to the charity. So another way we can help charities that can work. So what steps should you be taking at this point? You should review your existing estate plan, not only about your IRA and 401ks, but your entire plan. Make sure it's up to date. Make sure it meets your desires. You should review your plan, your IRA and retirement accounts, and think about what changes do I need to make because of the new laws? What changes do I need to make because it just is common sense and it makes sense for you to do it, like the use of the accumulation trust? And review any existing IRA accounts that you've set up. Review your beneficiary designations to make sure that they make sense. And if you have set up a trust to be the beneficiary, now with the new rules, that trust may have to be tweaked. There may have to be changes made in the trust. And so these are steps that I would highly recommend everyone take. Now, if you'd like a more detailed explanation and presentation, I am going to give a workshop on March 19th at 10 o'clock in the morning here at my law office in Garden City. So March 19th at 10 o'clock, you can register by phone at 516-683-1717, 516-683-1717, or you can register online. So starting tomorrow, you'll be able to go on my website, V for Vincent, J, RussoLaw.com, VJRussoLaw.com, and you can register online. We'd love to meet with you and go into more detail and do what we can to make sure that you've got the best plan in place for yourself and your family. So thank you, Hilary.
So I just, I want to thank you, Vincent. This was so informative. And I have to say to you guys that if you are concerned about your IRA, you should definitely be at this seminar on March 19th at 10 o'clock at Vincent Russo's office. It's the Russo Law Group in Garden City. Thank you so much. I want to thank our sponsors, the Profit Express, Fortune Fine Jewelry, and the Russo Law Group for hosting this show. And last but not least, I want to thank you, our listeners, for tuning in. If you want more information on this show or any other show, visit our podcast website at hilarytopperonair.com, or you can find us on Spotify, iTunes, Google Play, even Amazon Alexa. We're out there. You name it, we're out there. And we'll see you next week. Thank you again, Vincent, for doing this.
My pleasure.
Great show.